Order! Order! You are an incorrigible delinquent at times. Behave yourself, man!
It's been day 3 of one of the most important constitutional cases in British legal history. The Supreme Court is hearing an appeal from the government to try and overturn a High Court ruling that said the Prime Minister could not trigger Article 50 and begin the process of exiting the European Union without a vote in Parliament. Watching it all has been our legal commentator Joshua Rosenberg. But let's begin by listening to Gina Miller's lawyer. She's the woman who started this historic fight. And Lord Panic begins by talking about the Referendum Act 2015.
Position. One has an act in the most general terms that simply does not address the division of power between executive and parliament. That's not the subject of the act. The act has nothing whatsoever to do with that topic.
It might be argued that it's a different type of act from most acts that Parliament passes.
The Act did have an effect. The Act had an effect.
Yes.
It provided for the referendum. The franchise in the referendum, which is
Absolutely.
different from the parliamentary franchise,
I was-
made it lawful to hold the referendum,
Absolutely.
do everything. The Act undoubtedly had a legal
Absolutely.
effect. The question is whether the result has a legal effect.
Well, I respectfully do. I'm sorry, my Lord Assumption wanted to ask me.
I was going to ask you exactly the same question.
Yes.
I'm sorry, I didn't make it a question. I should have done it.
Could I
Mine's not.
I'm grateful.
Well, Joshua, Lord Panic was getting asked questions from all sides there. It sounded like quite a lot to juggle.
It's a fundamental question. The 2015 Act, the Act that allowed the referendum to take place, is famously silent about the consequences of a yes vote. And people are trying to work out what Parliament intended when it clearly said nothing. The government says it's very clear. Parliament did not intend there to be another vote in Parliament. Parliament didn't say there needed to be more legislation. Parliament was silent, therefore the government can use its prerogative powers. Lord Panic says the opposite's true. There's nothing in the Act to give the government powers, and therefore the government can't assume powers. It needs to go back to Parliament.
So a real key part of the argument there. Let's hear, shall we, how Lord Panic closed his case.
Lords, my lady, the submission for Mrs. Miller is that the volume of materials before the court, indeed the volume of lawyers before the court, and the eloquence of my friends, the Attorney General and Mr. Eadie and the Advocate General for Scotland, should not be allowed to obscure the basic principles of constitutional law, which I say the appellant's argument would violate. Those are the submissions I want to make, unless there are other matters on which I could seek to assist the court.
Thank you, Lord. Thank you.
So that sounded like quite a low-key ending from Lord Panic. What did you make of his performance?
It was, but of course this isn't a jury trial, and the submissions that he makes are ones which the court will understand. Whether they accept them or not, we shall wait to see. His point is a fundamental point. These are powers granted to us here in the United Kingdom by Parliament. Only Parliament can take them away. Ministers can't do it. That's his fundamental constitutional point, disputed by the government, which says that the government has these powers under the royal prerogative. And that's what the case is all about, and we shall wait and see what the court decides.
Now, we've heard a lot from the lead respondent, Gina Miller. Here she is arriving at court this morning, or from her lawyer, we should say. Now, she's not the only one who brought this case. Diego dos Santos is the other key respondent, and here is his lawyer arriving this morning. Mr. dos Santos didn't seem to be in court himself. Like Gina Miller, he's received some death threats over this case, so it may be that he decided to keep a low profile. So let's take a listen now to his lawyer, Dominic Chambers, answering a question from Lord Carnworth.
The one-line bill doesn't solve any of the problems. It doesn't solve any of the problems of what we do about all the detail. But you say that is a sort of magic wand which makes all the difference.
My Lord, certainly not a magic wand. There are two stages. There is the trigger stage, and then there is what's going to happen after the trigger stage. Your Lordship referred to, the Great Repeal Bill. That is after the trigger stage. We have to concentrate on the trigger stage itself.
Not necessarily, because obviously everyone accepts that there's got to be legislation in due course.
This
Well,
court is not...
But that's Lord Carnworth's question.
Yes.
That what we would say in those circumstances
to the executive, even though Parliament's given you a clear path through a motion of both houses, you still have to go back to Parliament and pass a statute.
My Lord, yes, that is absolutely correct.
That is the case. Yeah.
Yes.
That is the case.
I understand it, and so be it.
Well, that's one way of casting it, but surely your argument is that it's for this court to decide whether or not the 1972 Act can be set at naught, as Lord Pannick has put it, by the exercise of the prerogative.
Now, it's interesting because it sounds a bit as though the judges are trying out their arguments in public.
They are, and you don't often get that, and I think those were really the arguments that they were thinking through, and there was quite a long riff, really, where they were bouncing arguments across the table, this semicircular table at which they sit, with Mr. Chambers standing in the middle, sort of fielding questions from all directions. And the questions were directed perhaps less at him and more at the other judges. And there were issues there that were very interesting. Lord Carnwath, again, has returned to the question that's clearly worrying him, which is the sort of legislation referred to as the Great Repeal Bill that will be brought into effect not to trigger Brexit if the court decides the legislation is needed, but a year or two on to give effect to Brexit, something that the High Court had nothing to do with. And he's also concerned about whether legislation is needed, or, as Lord Kerr was suggesting, maybe a motion. And Lord Sumption said, well, look, parliamentary motions don't change the law. That's what an Act of Parliament is for. And that, of course, is what Lord Pannick is arguing over. So they're clearly working out not just whether the prerogative is good enough or not, but if it's not, what needs to be done about it.
So we're getting a bit of an insight, really, into their thought process as the case goes on. Now, we've already heard from the Advocate General for Scotland pushing the UK government's case, but on day 3, it was the turn of the Scottish government's lawyer, the Lord Advocate. He supports Gina Miller's side, so let's take a listen.
The basic point is that when one's testing whether the Crown can, by the prerogative, change the law of the land, one has to keep in mind that in the current constitutional arrangements, there are several legislatures which have an interest in that question.
Not even Parliament can change, you say, so how possibly could the government?
Well, I say there is a convention,
yes,
a constitutional requirement, I would say, that Parliament has itself acknowledged in statute.
Right.
I think what you can say is that Parliament, at the very least, commits itself to the question whether it should legislate on a matter which is within the competence of the Scottish Parliament. It would be incongruous with that situation that the government would, in effect, change the law of Scotland.
Absolutely.
So, Joshua, what do you think the significance is of that exchange?
The Lord Advocate, on behalf of the Scottish Government, accepted that the Scottish Parliament couldn't veto Brexit. But he pointed out that there was a convention, which we call the Sewell Convention, after the Minister, Lord Sewell, who referred to it in Parliament in 1998. He said that he thought that when devolution went through, a convention would be established that Westminster wouldn't normally legislate with regard to devolved matters in Scotland without the consent of the Scottish Parliament. And what the Lord Advocate is saying is that that convention, it's only a convention, it's only an understanding, it's only an agreement, but it is enshrined in the Scotland Act now. It is enshrined in law in those terms. Wouldn't normally legislate without the consent. And he's saying that it would be unconstitutional, it would be bypassing the Scottish Constitution for the UK Parliament, when legislating for Brexit, which is what he says needs to be done, not to take account of the views of Scotland.
Interesting. Now, there were also a few moments of humour in court. At one point, nobody seemed to know the correct pronunciation of De Keyser, or should that be the De Keyser case? Even lawyers and judges get it wrong sometimes. Let's have a listen.
Can I come on to the 5th topic, which is De Keyser and the other case law? De Keyser was concerned...
Have I been mispronouncing that case all my adult life?
Would your ladyship like to tell me the correct...
De Keyser.
De Keyser. I will call it De Keyser.
No, you needn't. I mean, I may be wrong. I'm often wrong.
You say De Keyser, I say De
Keyser. Down here we think it's De Keyser. We think it's a third.
It could be De Keyser, yes.
Well, we can each stick to our own because the transcript won't give away what we've called it.
Yeah.
It's my 5th topic, whatever it's called, and whatever it's called, MS page 228, CA2 tab 10.
OK, Joshua, let's put you on the spot. Who's right?
Well, I can tell you it's spelt D-E, next word K-E-Y-S-E-R. It refers to a hotel in London which was occupied by troops during the First World War under prerogative powers. And it was founded by a man called Sir Polydore de Keyser. He was a Belgian. He became Lord Mayor of London, but he was born near Ghent. Now, I don't know whether he still pronounced his name in the Belgian way when he came to London, or whether he anglicised it, and he's not around. He died in the 19th century. We can't ask him, but one for the law students.
So that's obviously one of the big questions on day 3, but what's your sort of final thoughts?
Well, we've got one more day, and we've got some of the interveners, and perhaps a quick chance for the government to respond at the end of the day. And I think you see the judges beginning to map out the territory that they find difficult and the questions that they find easy. What they're going to do after this case is over is sit down in a big room and chat, and then they're going to start exchanging by email drafts of their decisions and work out what they think the answer is. And if there's a majority rather than a unanimous decision, well, which side does the majority come down? And that's just something we can see them working out just as the case ends. But of course, they won't really seriously begin until they've heard all the arguments.
Joshua Rosenberg, thanks very much for your thoughts on day 3 at the Supreme Court. We've heard in depth from both sides now in this landmark court case, but Thursday will be the final day in court, a final chance to win over the 11 judges.
I've been getting